I think one of the things that really surprised me about the safe harbour regime being struck down was a number of my clients who simply did not know what contracts they had, where data was going, why the data was being shared, or indeed who had signed the contract, when it dated from, and indeed in some cases whether there was a contract. Those days are long gone, so the GDPR is pretty prescriptive as to the contents that you have to have in those contracts. And one of those is obviously the subject matter, duration, type of data, etc. And I think to make it a living arrangement, what you should really do is have that kind of information in a schedule rather than in the sort of body of the contract, so it can be much more amenable to that living arrangement. Next one I want to touch on is in 28.3c around the security provisions. So again, GDPR requires you to have those provisions in the contract. And GDPR requires controllers to put the right security in place and processors to put the right security in place. But what it doesn't do is actually deal with when the controller and processor do not agree. So fundamental contract requirement or addition that we'll look at on the next slide is actually putting that in place. But understanding that the regime in which this particular processor is operating, or indeed the regime, if you are a processor, that your controller is buying from you. Clearly, if you're a cloud provider, you won't want to have a million variations of different security requirements. You'll have one fixed system, which is largely a take it or leave it. Whereas if you're buying a bespoke solution, or if the controller is buying a bespoke solution, then that is clearly not the case, and there will be that degree of negotiation around what kind of data is going into the system and the right kind of obligations in relation to it. I know that, and I don't know what I did in a previous life, but I've dealt with a lot of data subject access requests in my time. I must have been particularly evil or something, but they always challenge the clients that I have, and in some pretty serious ways. Now again, in your controller to processor subcontract, you need to not only deal with subject access requests, but the whole host of other data subject rights which come in under GDPR. So ensuring that you have a process that works for those, not that's just written in the contract, but actually applies in practice, because clearly 40 days comes down to a month, which is 30 days, and data subjects are going to be, one, pretty informed about what's going on, because I think the EU is going to do a lot of publication as to the GDPR, as is the ICO. I think the last one that I want to touch on then is around deletion or return of data on termination. So again, quite a vanilla sounding statement in the GDPR, but this is going to have quite a lot of life. So if a particular service under a master services arrangement comes to an end, that is the point where that data needs to be either returned or deleted at the controller's option. It's not simply good enough nowadays to allow that data to stay on a system pretty much forever or until the contract ends.